Hey everyone, before I go too far into what exactly my concerns are with this bylaw, I just want to say a couple things right quick. First of all, I'm not a lawyer or any kind of legal professional. These are just the concerns I have when reading through this as an ordinary person. Next, I do have and have had concerns with the municipal dog registration policy and what I assume are the previous bylaw, but the previous bylaw was bylaw 111 or 111A, and it's not available on their website anymore, so it's hard to verify. And next, I want to recognize that I don't think that staff or council are being intentionally malicious with this bylaw. It's not like they're trying to kill everybody's dogs and throw everybody in jail kind of thing. They're more, as far as I can see it, trying to cover all their bases in case there's something they do feel they need to act on. But that said, I don't think that excuses all the concerns that I have with this bylaw and how poorly worded and far-reaching it is. So with those said, let's get into the actual bylaw. This is the bottom. I was under the impression it needed a third reading, but I could be wrong on that, so if anybody knows, feel free to put that in the comments. Fill me in, please. But up to the top, here's some technical stuff. The definitions. The definition of animal in this bylaw is an animal that's owned by a person under the care and control of a person. Attack under this bylaw, their definition is to injure, scratch, bite, or to threaten or give the impression of threatening, which is very subjective and up to the individual who feels threatened, or an assault resulting in real or perceived, which goes into the last thing, injury to another person or animal. Let's keep going. Bylaw enforcement officer, somebody the municipality decides to enforce this bylaw. Fierce or dangerous dog means any dog that hurts a person, hurts an animal, that attacks or demonstrates a propensity, tendency, or disposition to attack a person or animal, either on public or private property, which sounds reasonable until you look at what their definition of attack and threaten were. That has caused injury to or otherwise endangered the safety of a person or animal. There. That threatens any person or domestic animal that is owned, trained part for the purpose of dogfighting or is trained for dogfighting. License means license tag or registering your dog under the bylaw, basically. Mitigating factor. Basically, these are if your dog behaves under their definition of a fierce and dangerous dog, and one of these three things applies, they don't consider it's excusable, basically. So the mitigating factors are the dog at the time of the aggressive behavior attacked or injured any trespasser on its property occupied by its owner. The dog immediately prior to its aggressive behavior was being abused, tormented by the person attacked or injured, or the dog was acting in self-defense of itself or a person. Some more technical definitions, municipality, etc. Muzzle, noise. Means of a humane covering device of sufficient strength placed over a dog's mouth to prevent it from biting. Owner means any person or body corporate who is the licensed owner of the dog, so the person who registered the dog, who has legal title to the dog and/or, so the person who owns the dog, whether it's registered or not. The person who has possession or custody of the dog, either temporarily or permanently. So the bylaw enforcer, the dog catcher who picks up your dog temporarily or permanently, owns the dog under this bylaw. Who has care and control of the dog, same thing. who harbors the dog or allows the dog to remain on his or her premises. Now that qualifies as the last two. I also, after reading that, would assume that it means, say your dog is running at large and a Good Samaritan lets your dog into the house, goes on any of the Lost Dog Facebook pages and finds you. That person was the owner of your dog under this bylaw for the period that the dog was in their house and on their premises. And the next part is, if any of the above are a minor, then it includes the person who's in charge of the minor. Owner of the premises. Running at large was another one that means any dog that is off property of its owner without being under the apparent restraint or control of some person shall be deemed to be running at large for the purpose of this bylaw. In all areas of the municipality, the owner of a dog shall, while the dog is off the property occupied by the owner, keep the dog under control by means of a harness or leash. The dog shall be deemed to be running at large where the owner fails to use such an apparatus. A dog which is tethered on a tether of significant length to permit the dog to leave the property boundaries of the premises occupied by the owner is deemed to be running at large. So, in that, I wonder, when they say occupied by the owner, do they mean that you're only allowed to have your dog off leash on your own property? Or does that mean that, say you're over at a friend's house, that you can let your dog off leash with their dogs on their property? You're occupying that property with your friend. Does it mean property that you own or property that you're at, is my question as far as that goes for now. Then there's the definition, threaten. Threatening means unmuzzled, leashed or unleashed, either one, or unattended by its owner or a member of the owner's family in a vicious or terrorizing manner. Sorry, that's comma. In a vicious or terrorizing manner, comma, approaches in an apparent attitude of attack upon the streets, comma, sidewalks, comma, any public grounds or places, or on private property other than the property of its owner, to any person or animal. This goes back to some of my concerns in the definition of attack, where really whether the person has been threatened and under this bylaw by being threatened also being attacked by a dog is dependent more on the feelings of the person being threatened than the actions of and behavior of the dog. Also, as far as this definition for threatened specifically, reading this, it seems to me that the only way that you could guarantee that somebody under this bylaw can't feel threatened by your dog is if you have it muzzled at all times when you're not at home. There's a few other definitions that I think should be included in here based on the definitions and wording of other parts of the bylaw later, but which haven't been included. Those include occupied, like I said. They also include injury, for things like the definition of attack and bite. It also includes neighborhood for some definitions later, and they go into canine madness, which they use in some of the later parts of the bylaw, but they also use the term rabid, which this is alphabetical. They haven't defined rabid here. Like, it's not there between P and S. It should be there somewhere. So, the specific parts of this bylaw that I'm concerned about, since we're done with the definitions, let's get down to dog attacks. The owner of any dog that attacks a person or other animal without the presence of a mitigating factor, which we talked about above, is guilty of an offense under this bylaw. keep in mind that is this bylaw's broad definition of attack, which includes threaten and feeling threatened by a dog. Now, I'm not saying that being afraid of dogs is irrational. Some people have experiences that make them have fear, and they could feel threatened by a dog which isn't actually presenting a threat to them. Things like that are kind of one of my big concerns with this bylaw. Let's go on to 7.2. Where a bylaw enforcement officer has reason to believe that a dog has attacked or threatened another person, by this definition, without the presence of a mitigating factor and the owner of the dog has been identified, the bylaw officer may, not shall, but may, issue the owner a notice to muzzle the dog, which requires the dog to be muzzled at all times when outside of its residence, including in the owner's yard. So at that point, if you got a notice, you would only be allowed to leave the muzzle off of your dog while it's inside your house, maybe a building on your property. Or issue a notice to the owner to microchip the dog and or obtain a warrant to seize and impound the dog for public safety until the owner satisfies the municipality that the dog is no longer a threat to the public, which I assume the owner would be charged for during the term of the dog's impoundment, which is the next part of the bylaw. 8.1. Any constable, peace officer, or bylaw enforcement officer, so municipal staff or cop, without notice to or complaint against the owner of any dog may impound a dog. So they don't need to notify you, and they don't actually need to have a complaint against you to impound your dog if it's found to be running at large, contrary to their definition in this bylaw, which includes having a leash that's too long and reaches off of your own property, which is rabid or appears to be rabid, or exhibiting symptoms of canine madness, both of which should be defined in this bylaw and not just canine madness, which appears to be threatening or fierce and dangerous, which we've gone over. They're a little bit open to interpretation, at least threatening in aspects to what qualifies as a fierce and dangerous dog. And 4, which persistently disturbs the quiet of the neighborhood or area by barking, howling, or otherwise. So, in 8.1, there are two very different kinds of complaints here. There are 8.11 and 8.14, which are basically nuisance complaints, and then there's 8.12 and 8.13, which they're a dog which I can only assume the intention behind this bylaw is addressing actual dangerous dogs here. So I think those two things should be handled differently, and it could be written into the bylaw to do that. It's not, but that could be done. Let's keep going. 8.2. Every owner who redeems a dog from the pound shall be liable for payment of all the fees incurred in impounding the dog, including but not limited to, so it could be more than this, but these are the things that they're saying you'll be charged for. The cost to pick up your dog, boarding your dog while it's there, the cost for feeding your dog, the cost for care for your dog, any veterinary fees that they administer, the fees for any veterinary care they administer to your dog, I should say, before picking up the dog. And this next part I'm a little bit unsure about. In addition, the owner must produce a valid municipal dog tag license before they can be redeemed from the pound. I'm not sure if that means you can't pick up your dog unless it's registered, or if you need to register your dog before they'll release your dog to you. I'm assuming the second one, but it could be either. Don't really know. 8.13 goes into the differences between if your dog is found without a tag versus 8.15, which is if your dog is found with a tag. basically, any dog with a tag shall require the municipality to give written notice to the owner, and only after written notice is given to the owner or left at your residence if they can't get a hold of you, shall a period of 72 hours, excluding weekends and holidays, begin. The registered dog may, after the expiration of that period, become the property of the municipality, and they may offer it to the SPCA for adoption. Now, if your dog doesn't have a dog tag, my understanding is they start the 72 hours immediately. And 8.14 goes into if your dog doesn't have a tag, if a dog is missing, the onus is on the owner of the dog to ascertain within the time period provided for impounding under section 8.4 of this bylaw whether the dog has been impounded. So I guess that would apply to in either case, whether your dog has no tag and it gets lost and the clock is starting, it's on you to find out that the municipality has picked up your dog. Or say you're away and you have a neighbor coming to check on your dog while you're gone, feed it, take him out, etc., etc. And something happens, your dog gets picked up for running around, maybe there was a window open. Hypothetical situation, the period of, they could leave the notice, written notice at your residence, and the period of 72 hours still starts. It is still on you, even though you've registered your dog, to find out that the municipality has taken your dog. So, a lot of these are leading into the next one, which is good. Seizure. So this is if the municipality or a cop takes your dog. Where a peace officer believes on reasonable grounds that a person is harboring, keeping, or has under their care, control, or direction a dog that is fierce or dangerous, rabid, which I'll remind you isn't defined, appears to be rabid, which is the subjective judgment of the peace officer, or that exhibits symptoms of canine madness, or that persistently disturbs the quiet of the neighborhood by barking, which is barking, howling, or otherwise, which is significantly different than the beginning part of 9.1. Excuse me. A justice of the peace may, by warrant, authorize and empower the person named in the warrant to open and search the place the dog is located, to open or remove any obstacle preventing access to the dog, and to seize and deliver the dog to the pound for such purpose, break or remove or undo the fastening of the dog to the premise. So, originally I thought Section 9 was a little bit worse than it actually was. After reading it again a few times, I realized that they actually do require a warrant, and I was concerned that the municipality and the council were okay with staff suggesting that they pass bylaws that authorize searches and seizures of property without warrants from a judge or a justice of the peace, whatever the difference is. But that's not the case here, which is good. I want to give them the credit where credit is due. It's still concerning, a little bit, but at least it's not saying that without a warrant they can come in and take your dog. They still need a warrant according to this part of the bylaw. But they can, when they are enforcing this, they can go onto your property, they can remove anything that they need to get to the dog, and if the dog is tied up or confined, they can break anything that they need to get the dog out of there and get themselves out of there, is basically what that's saying. Destruction of the dog. This one is kind of controversial. Where the owner of a dog, which is fierce or dangerous, by the definition in this bylaw, or 2, which is rabid, which isn't defined in this bylaw, or appears to be rabid, exhibiting symptoms of canine madness. This next part is a little weird. Or has euthanized or caused to be euthanized said dog, shall provide to the municipality or the bylaw enforcement officer, upon request, evidence of the euthanization. So if they think your dog is dangerous, I'm not, yeah, I'm looking for clarification on this one is basically what I'm thinking. 10.2 concerns me. 10.1 kind of confuses me a little bit. Is it saying that the municipality can order dogs to be euthanized and that the owners need to provide proof of that? Or not exactly sure what's going on, but I feel like it's noteworthy anyway. Let's keep going. This came up in East Hants Wants to Rant and Rave recently. It's the part about running at large. Let's just read it through first, and then maybe unpack it a bit. 10.2. Municipal staff may, after 2 written warnings have been given to the owner that a dog has been running at large or eluding capture, kill such dog on site or after they capture it. Municipal staff may destroy on site any dog that is running at large, by the definition of this bylaw, and which the bylaw enforcement officer believes on reasonable or probable grounds to pose a danger to a person or domestic animal or to property or person other than the owner. Which leaves it's a little bit up to interpretation. What exactly is damaging a person's property? I understand the need for something that immediately allows somebody to act in their own self-defense if they're being attacked by a dog or if somebody else is being attacked by a dog. But this is written in such a way that I do think that it leaves a little bit too much leeway for interpretation up to the person that's enforcing it. I want to skip ahead to number 12 because this is another big one. And I want to unpack 12 in full. 12.1 Penalties. A person who does anything prohibited by this bylaw, or who neglects or fails to do anything required by this bylaw to be done to him, is guilty of an offense, and except where some other penalty is provided by this bylaw for the act, refusal, neglect, or failure, is liable on summary conviction to a penalty of not more than $500, and in default of payment, to imprisonment of a term not exceeding 10 days. So that's outside of Section 6 of this bylaw. If they find you in infraction or violation of anything else in this bylaw, they can hit you with 12.1. $500 fine, 10 days in jail, max. 10.2. Every owner of a dog that commits an offense under Section 6 of this bylaw upon conviction shall be liable to a penalty of not more than $5,000 and in default of payment to imprisonment for a term not exceeding 30 days. Any person who obstructs or hinders the dog control officer in the performance of their duties under this bylaw is guilty of an offense and is liable upon summary conviction to a penalty of not less than $100 and not more than $10,000. So they need to charge you at least $100 if they end up taking you to court under Section 6 of this. They can't charge you more than $10,000, but they have to, if you're found guilty, at least charge you $100 under this. And in default of payment to imprisonment of a term of not more than 2 months. So if you don't pay, they can throw you in jail for 2 months. Now, Section 12.2 relies on Section 6, so let's go read Section 6. Responsibilities of the dog owner, which should really, in my opinion, more be phrased as the offenses of the dog owner, the consequences of breaking this bylaw or transgressions of a bylaw or a dog owner, but I digress. The things that they're talking about charging you $5,000 max in Section 12.2 is if your dog runs at large under this bylaw. Anybody whose dog is not wearing a tag, so if you don't register your dog under this bylaw. Anybody who's not licensed pursuant to this bylaw. So it's 3 is not being registered. 2 is if you forget to put the tag on your dog, or your dog doesn't have his collar with his tag on. 4. Whose dog persistently disturbs the quiet of the neighborhood by barking, howling, or otherwise. Your dog barks too loud or too late at night, they might charge you up to $5,000 or jail time. 5. Whose dog, at any time without the presence of a mitigating factor, has attacked or injured any person or animal or damaged any property at all. 6. Who harbors, keeps, or has under their care, control, or direction a dog that is fierce or dangerous, which is this bylaw's loose definition of fierce, dangerous. 7. Who fails to remove the feces of such dog, other than a service dog that is trained to assist and assisting a person with a disability, from public property or private property other than the owner's. You don't pick up the poop after your dog unless your dog is a service dog and registered as such. They can charge you $5,000 for the poop. Any owner whose dog damages public or private property. 9. Anybody or any owner who sells or transfers a registered dog and does not report the sale or transfer to the dog enforcement officer, along with the name and address of the person whom the dog was sold or transferred, a description of the dog, and the dog's registration number. So, if I was to sell my dog back to the person I got it from, and I don't inform the municipality of that, under what's listed here under section 9 of 6.1, they can charge me. Is there any more to this? Is guilty of an offense under this bylaw. And 6.2. When requested to do so, the owner shall deliver to municipal staff a statement in writing of the number of dogs owned or harbored or habitually kept on the premises of the owner. And in the event the owner neglects to refuses to provide the statement within a period of 10 business days after having received notice requiring the statement to be provided, shall be guilty of an offense under this bylaw, which then subjects you to the penalties here. Not more than $5,000, and if you refuse to pay, a jail term of not exceeding 30 days. Any person who obstructs the dog control officer in the performance of their duties under this bylaw is guilty of an offense. It's basically double what the first part of 12.2 is. If you try and hinder or argue or whatever, they can charge you up to $10,000 and a jail term of 2 months instead of the equivalent of 1 month. 13 is fees. The only one I really feel the need to go into here is 13.15. No animal shall be released to its owner until such owner pays all the fees, costs, and expenses of the shelter keeper while the animal is impounded at the shelter, which seems like it encompasses some of the stuff we've already talked about and probably most of the rest of 13. And section 11, in the event of an emergency, which is in one of the definitions above, or during the course of normal bylaw response, it is suspected that the dog has been abused or neglected, the bylaw officer must notify a peace officer having authority under the Animal Protection Act. This is provincial legislation they're talking about. The officers may, with the assistance of the bylaw enforcement officer, take the dog into protective care, and if necessary, provide veterinary services to such dog. The cost of care and any veterinary services so provided shall be paid by the owner. These instances must be reported to Nova Scotia's SPCA, etc., etc. These aren't things that I think the average person would have a problem with. The reason I bring up and read section 11 is because it mentions the Animal Protection Act and Nova Scotia's SPCA. I think a lot of what's contained in this bylaw, like overall the bulk of this bylaw, is already covered under the Animal Protection Act, and I do think that duplicating things on several levels of government is inefficient and unnecessary, and it's something that our council and through our council should be encouraging the municipal government staff to avoid. And yeah, that's mostly what I wanted to cover. I think I got everything. The only thing now is what's the next steps, like what action do we take if any of these things do concern you. I imagine some of them should, maybe not all of them. But I'm not quite sure where next to go with this. Maybe people want to talk about it more on social media and share this with their friends and followers. Maybe people want to express their concerns with their municipal councillor and let them know how you feel and that you think that this bylaw needs to be either changed or repealed completely, depending on your own personal opinion. I don't know. Let me know in the comments. I appreciate you taking the time to watch this video. I know it's been pretty long, and I hope you have an awesome rest of your day.